Well, today you're going to see the sovereign citizen pseudo-lawyer Marc Stevens. Now, he's the one that has written out all these scripts that people follow in court and that you've seen previously. What's interesting is, even with all his bluster and bragging, this is the only evidence, the only video of Marc Stevens ever being in court in front of a judge. So sit back, relax, and have a good laugh.
Yeah, test. This is Marc Stevens. Is that better?
Yes, thank you.
Okay, we are back on the record. So I read the hearing notice, the statutory authority. Now I'm going to determine who is present here today, and I'll start with the state, since the state brought this petition.
Thank you. Jean Killam for the Police Department in the Assistant County Attorney in Cheshire County.
And spell the last name, please.
Kilha.
I'm sorry. I can't hear her.
I'm not sure what we're going to do about that, sir. I only have so much technical.
Is the microphone on this thing?
Yeah.
Maybe move that a little closer.
Well, it's going to have to be moved every time somebody speaks, and I don't know how we're going to manage that.
Even if we can just move it like maybe to here.
Let's see how far it'll go.
You want to turn it toward him, you know?
I don't care if you can see me. Just maybe you could speak up to me.
Okay, why don't we try it again and see if he can hear you this time?
That's Jean Killam for the state.
Actually, I had an initial objection. I have an objection to Miss Killam appearing today.
Basis of the objection?
Yeah, the objection I have is that I believe she's bringing a complaint knowingly absent evidence of jurisdiction. We've had prior experience with Miss Killam. I've spoken with her on the phone. Mr. Freeman has had a formal disclosure that was sent to Miss Killam. She wound up this was with a criminal charge that was filed previously with the court. She wound up withdrawing that. I've subsequently followed up with her, not gotten any evidence from her proving that the Constitution laws of the state of New Hampshire actually apply to Mr. Freeman. And so I believe her appearance today is disingenuous at best, that she's knowingly proceeding absent evidence of jurisdiction. I also have an objection as to whether she's appearing on behalf of the state, but I'd like to address the issue that she's proceeding absent evidence of jurisdiction first.
We have her sit maybe one seat closer to us.
Why don't you move over?
I thought Sergeant Short would sit here waiting.
Well, why don't you move over until we get
Okay.
through this? I guess I'm going to address you first. This is a duly convened hearing of the Department of Safety based on a complaint brought by the Keene Police Department. And I recognize her as a member of the Bar of the State of New Hampshire. I'm not sure what your authority is, sir, but she's a member of the Bar of the State of New Hampshire. As far as I'm concerned, she can appear here, and I don't know as though you've said anything that makes me think otherwise.
Well, I believe she's filed a complaint with the DMV knowing that there was no evidence of jurisdiction, that there was no evidence to prove that the Constitution laws of the state of New Hampshire actually apply to Mr. Freeman, and that she has purposely withdrawn her complaint in the court to bring it here to enjoy a lesser standard of proof, which even with the lower standard of proof, because she has no evidence to prove that the Constitution laws apply and can't establish jurisdiction over Mr. Freeman, that we shouldn't be permitted to have a hearing at all.
How do I know that she doesn't have any evidence if I haven't heard anything yet? And also, why do I need a constitutional authority to hold this hearing when this is a statutorily and administrative rule appropriate hearing?
Because it goes to the issue of jurisdiction over Mr. Freeman, that Ms. Killam is under the impression or is arguing that the constitutional laws apply to Mr. Freeman, thereby giving her and the police department jurisdiction and also giving your agency jurisdiction to have a hearing and make a decision affecting Mr. Freeman's life. So it's an issue of fact, not a constitutional issue or an issue of law. If Ms. Killam has evidence to prove the constitutional laws apply to Mr. Freeman, then she needs to present it right now.
I'm going to go
This is
right.
the only way she can establish jurisdiction.
I'm denying your motion, sir, and I'm going to go right to the evidence today.
Well, on what grounds? Do you believe that she has evidence to prove the constitutional laws apply to Mr. Freeman and there's jurisdiction?
By statute and rule, this is appropriately convened hearing, and we're going forward.
Well, objection. Are you saying that there is evidence to prove that the constitutional laws apply to Mr. Freeman that you've gotten from Ms. Killam?
I'm not entirely sure what constitution you're referring to start with, sir.
I believe it's the New Hampshire Constitution that's being applied to Mr. Freeman.
Okay.
So again, my question is, has Ms. Killam provided you evidence to prove that the constitutional laws of the state of New Hampshire apply to Mr. Freeman that would then enable you to have jurisdiction over him today?
Well, she hasn't put on her case yet, so, and I'm not even sure that I need proof of constitutional authority. I mean, I believe I have it, but as far as I'm concerned, this is a duly convened hearing of the Department of Safety. I'm the Commissioner's designee. We have statutory and rule authority to go forward here today, and we are going forward.
I think what he's asking.
Well, I'm sorry, Ian.
Yeah, maybe just to rephrase my understanding, what he's saying is that, you're saying you have the statutory authority to move forward, but I think the objection is whether or not the statutes actually apply to me.
And how can I do that until I hear evidence?
Well, because Ms. Killam she had filed a complaint. She is required to establish jurisdiction before any hearing is put on. So my question goes, again, what evidence has Ms. Killam provided you so far to prove that the constitutional laws actually apply to Mr. Freeman and that there's jurisdiction to proceed against him?
I think that will play itself out during the course of the hearing.
Objection. I believe if you believe you have jurisdiction to actually conduct a hearing, I want to know what evidence you're basing that on that you got from Ms. Killam. Do you believe that you have jurisdiction to conduct a hearing?
All right, I guess I should go back to the hearing notice and the statutory authority for the hearing because we did not have you on the record at the time. Mr. Freeman has been ordered to appear and show cause why his driver license or operating privileges should not be revoked or denied. To review receipt of information submitted from Keene Police Department that you could be hazardous to public safety. The person who shall be subject to such an order shall include but not be limited to one whom, and I will narrow it down, number 2, a law enforcement officer has reported for misconduct. That is appropriate based on RSA 263-56, 263-59, Administrative Rule SAFC 20403, Administrative Rule SAFC 20413. That's my authority.
Okay, now the question is, has Ms. Killam provided you with any evidence to prove that the constitutional laws of the state of New Hampshire actually apply to Ian to prove that you have jurisdiction or to establish your jurisdiction?
No.
What has she given you evidence-wise to prove that the codes apply to Ian?
I have statutory and administrative rule authority to conduct this hearing, and as far as I'm concerned, that is all I need. Would you like me to go?
Objection. What evidence? Let me finish. I'm objecting
No,
because you're
I'm
giving
running
me
this
a
hearing, sir.
circular.
I'm
Let me
running this
finish,
hearing,
sir.
Okay? And I also have the authority to disconnect you whenever I want if I think you are being disruptive to getting this hearing done. Do you understand that?
I understand. I'm not being disruptive, though. You haven't answered the
Well,
question.
so
What
far, you're not
evidence
allowing me
has
to
Ms.
conduct the
Killam given
hearing.
you?
You're not allowing me to conduct the hearing that I am, by statute, allowed to conduct by the Commissioner of Safety. That's how you're being disruptive.
I think he's just asking
No,
for
I have
evidence.
I'm asking for
statutory
evidence.
I have statutory and rule authority to conduct this hearing. I am going forward on that basis.
The question, I think, is what is the evidence that those statutes apply to me? I'm not here.
I don't need evidence, I just need statutes.
No, I'm asking for the evidence that the statutes apply. So you're obligated to follow the statutes because you've sworn an oath to do that, but I don't see any evidence that I've done that.
That will be part of the hearing in chief. That I will be making determinations based on New Hampshire constitutional law, statutory law, administrative rules, and I am convening this hearing. We're going forward over your objection, sir. Okay? And over your objection.
Well, I have a point of clarification, sir. Are you acting under the auspice or the opinion that Ms. Killam has presented you evidence proving the Constitution laws apply to Ian and that you have jurisdiction? I just want to be clear about that.
She has given us a prima facie case that Mr. Freeman has been guilty of misconduct in operating a motor vehicle in the state of New Hampshire. Now it's up to the state to give me sufficient evidence today to support their prima facie allegation that caused this hearing to be scheduled.
Well, I still would like you to be very clear that you're assuming jurisdiction without any evidence so far that you had from Ms. Killam. You're just assuming that the constitutional laws apply to Ian and that you have jurisdiction. Do I have your position correct?
There is a statute that says that a local police department can report a driver for misconduct. We received that report by statute. We then convene a hearing to determine if there is any evidence to support the report. That's the basis I'm going forward.
Okay, but my objection is to the assertion of jurisdiction, and you keep going back to the statute, and it sounds like you're making a logical fallacy, a circular argument. Basically, it's very similar to what prosecutors and people, like Ms. Killam do. If I'm getting this right, you're saying that when I ask for evidence that the Constitution laws apply, you keep going back to the statute itself. So are you saying that you have statutory authority to conduct the hearing or statutory jurisdiction over Ian because the statute says so?
Yeah. That's what I've been doing for 15 years, and I'll continue to do it today.
Well, with all due respect, sir, your time on the job is not relevant to whether Ms. Killam has provided you with empirical proof that the Constitution laws apply to Ian and that there's jurisdiction.
As an administrative hearings examiner, it is not my job to make constitutional determinations. It is my job to apply statutes and administrative rules, and that's what I'm going to do today. And we are moving on at this point. Over your objection.
Well, no objection. Well, sir, you're mischaracterizing.
And if you keep disrupting this hearing and preventing me from conducting this hearing, I am going to disconnect you.
Well, you don't have to threaten me because I just want to point out on the record, since we're going to have a record for appeal, you're mixing an issue.
Sir. You don't have to be repetitive.
But you see. No, I need to point out that you're misconstruing an issue of fact with an issue of law, and you're not making a proper determination. I'm not asking you for a legal issue or a legal determination. I'm asking you for evidence. It's an issue of fact, so please don't confuse the two or conflate the two any longer. I'm asking what evidence you rely on to show that Ms. Killam has given you to prove the Constitution laws that you rely on actually apply to Ian.
We will determine that by evidence today, sir. The hearing is legally convened, and I am to hear evidence. That is my ruling. We are moving on.
Oh, I still have an objection. She's saying she represents the state today?
This is your last warning, sir. You are disrupting this hearing. I'm going to disconnect you if you do not allow me to conduct the hearing in the way that I see fit. Do you understand?
I do, but I have a legitimate objection.
I'm going to count to 5, and if you say another word, I'm going to disconnect you. I have that authority under the administrative rules. 1, 2, 3, 4, 5. State may present its evidence at this time.
The state has Jason Short.
Will I be able to ask him questions?
You either have a legal representative or you're representing yourself. What's your decision, sir?
Are you going to allow me to speak then? Because you just did a countdown to 5 that I'd be disconnected if I spoke again. Because I do have an objection to the appearance of the police officer. I don't believe that Ms. Killam has any evidence that he has any personal first-hand knowledge that the Constitution and laws of the state of New Hampshire apply to Ian.
He doesn't need that knowledge, sir.
He doesn't need he's allowed to speculate in this hearing?
He is going to testify about his knowledge of facts as they apply to his knowledge of law in the state of New Hampshire.
But one of the issues he has to prove, one of the elements, is that he has to prove that the Constitution and laws of the state actually apply to Ian. And if he doesn't have personal first-hand knowledge... Well, let me finish.
That's your opinion, and I have not accepted that opinion at this point. So now the question
what I'm
to you,
asking
Mr.
is,
Freeman,
does Ms. Killam have...
Mr. Freeman, either he is representing you and he will ask the questions, or you are representing yourself. You need to tell me right now.
If Mark would like to continue, I'm happy to have Mark continue at this point.
Okay, and that means that he asks the questions and you do not. He can put you on to testify at some point if that's what you desire. But I am not going to have him ask questions and you ask questions and him ask questions. It's not the way we're conducting this hearing today.
As long as he's allowed to ask questions, I won't ask questions.
He's going to be allowed to ask questions as long as he's not disrupting the flow of the hearing. If I determine he is, he will not be allowed to talk anything. And then you can take over. All right?
Okay.
Officer, raise your right hand, please.
Objection. My objection has been heard and determined. Does Ms. Killam have any evidence to show that the witness has personal knowledge?
I think I ruled on your objection, sir, and we are going forward with evidence. And if you...
So let me, just a point of clarification. You're going to allow the witness to testify.
If you're going to keep beating this dead horse, then you will be disconnected.
I just need to understand your decision. You're allowing the witness to testify without any showing his personal knowledge of the matters.
Who doesn't have personal knowledge of the matter? The officer, I believe, does, and I don't know that until he testifies, do I?
Not necessarily. We've had enough experience with Ms. Killam that she would be able to determine, should be able to determine before she puts a witness on the stand that he does have personal... You need to let me finish.
Do you understand that? I have no experience with
But Ms. Killam has. Ms. Killam has filed a complaint and is basing everything on this witness's testimony, and she is responsible as the prosecutor to be able to confirm that the witness does have personal first-hand knowledge of the evidence before she puts him on the stand and calls him as a witness.
I need to make that determination, sir. She's prosecuting the case. I need to make the determination whether I think his testimony is reliable, and that's what the rules say. Okay.
No, Rule 602 says that no witness may testify to a matter unless there's evidence showing that they have personal knowledge. And that's all I'm asking is for Ms. Killam to be able to confirm that the witness has...
What rule did you just refer to?
Rule 602.
What rule is that? I don't have a Rule 602.
Rule 602 is in the Rules of Evidence that give some of the qualifications for a witness.
Federal Rules of Evidence, sir?
I believe that it's the New Hampshire has the equivalent to the federal rule.
This is an administrative proceeding. We have administrative rules. That's what governs this hearing.
Okay, so let me just understand correctly that a witness may testify without a showing from the prosecutor that they have personal first-hand knowledge.
He is a witness who has information that is relevant to this proceeding. I can accept hearsay. I can accept... He could testify to hearsay, and I can accept that based on our rules. And he is...
So you're going to... Okay.
And he's going to proceed to testify.
I did an administrative... Yeah, okay, I just do a point of clarification because I just did this with the NHES a few days ago. I want a clarification on when you say hearsay. Are you going to accept hearsay from the police officer from an unidentified source?
I can. I don't have to.
You can accept a statement from the police officer that he's giving secondhand from an unidentified source.
Administrative hearings shall not be bound by common law or the rules of evidence. All relevant evidence shall be admissible. The examiner may...
Okay, so...
Examiner may
you would consider it credible,
immaterial, or unduly cumulative or repetitious evidence. That is SAFC 203.19. That applies to this hearing.
Okay, so just to be clear, you would consider credible a statement from the witness secondhand from an unidentified source.
Sir, he can testify to it. Whether I determine it's credible or not is a determination I make in the overall decision on the case.
Okay, so it is something you would possibly accept. I'm just trying to see what kind of standard of proof that you hold, sir.
We have a preponderance of the evidence standard, sir. And hearsay is admissible, but I have to determine its reliability and the weight that I give it in the overall determination. Any further questions?
Well, I still object to the witness being put on the stand because I don't believe he has any relevant testimony to give.
And I don't know
and
that
with
until
personal
he gives
knowledge
the
that
testimony. Objection overruled. Officer, oath. Do you swear the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and your occupation.
My name is Jason Short. I'm a police sergeant for the city of Keene, New Hampshire.
And you may inquire, Attorney Killen.
Thank you. Are you a certified law enforcement officer in New Hampshire?
I am.
How long have you been in the city of Keene?
14 years.
Drawing your attention to February 7th of 2013 at about 11:40 a.m. Were you on duty for the Keene Police Department?
I was.
And were you in full uniform and operating a patrol cruiser as of that time?
Yes.
And
Excuse me, I'm sorry. I can hear the police officer. I can hear the witness fine. She's completely
Let's see if
garbled.
that will go over under that table.
I don't even know if my camera can hear it.
I can't, I'm having trouble hearing her as well.
That's not my problem. But you want to see if the camera...
Again, the police officer is coming through loud and clear. It's Miss Killam that is completely
It
garbled.
doesn't look like it will. You think so?
Maybe you could just scooch the table over a little.
We don't have much table here. Maybe she could sit in this chair and you could, oh, your table. Okay.
See if it'll go in that corner. All right, please continue.
thank you. And about that time, again, February 7th of this year, 2013, at about 11:40 a.m., where were you? And what, if any, vehicle caught your attention?
I was on George Street heading, I guess what would be westbound, coming up to Washington Street, when I observed a car, black and white. I guess the way the sun hit it, I could see fully that it said police on it. Didn't really take my attention too much, other than I didn't recognize it as a local police department's car. I came to the end of the street, I turned right, or I looked right, and I saw that the plate in the back was a bright yellow fluorescent plate. I lived all over the country. The only other plate that I could think of that would be Arizona, which threw me off guard because it said police on the side of it. So I caught up to it. I couldn't read the plate. I was able to pull alongside the vehicle close enough for me to be able to read it, just because of the way the sun was hitting it. And I saw that it said the Shire on it, or something along that line. I didn't recognize the car. It belonged to Mr. Freeman here, who I know is Ian Bernard or Ian Freeman. I recognize the car. I know that it has Wisconsin registered plates, but that plate was not on the back. It had this novelty plate, so to speak, as far as I was concerned. So I stopped the vehicle to inquire where the actual registration was.
Okay, and where did you actually conduct it?
I'm going to object to the question. I don't see where any relevance to proving that the Constitution and laws of the state of New Hampshire actually apply to Ian.
Overruled. You may continue.
Excuse me, just point of clarification. On what grounds do you see that the question is relevant to proving that the Constitution and laws apply to Ian?
That will be developed during the course of the testimony and the any issues of law that you would like to raise. But right now I'm hearing evidence, and I will determine whether it's relevant.
Okay, so just so I understand, you're not seeing any relevance at this point. You think that Ms. Killam will develop that during the course of the direct examination?
The testimony that they present will be weighed against the laws of the state of New Hampshire. You and I may have a disagreement as to whether the Constitution of the state of New Hampshire and the laws of the state of New Hampshire apply to Mr. Bernard, Mr. Freeman, whichever we call him. But that's going to ultimately be up to me.
Well, I'm just trying to understand where you're coming from. Do you you also don't believe at this point that there's relevance?
I've made it clear where I'm coming from, sir. We will proceed with the evidence.
And where
So you believe that? I just need to understand, because from what you've said, it's a little confusing. I want to be able to understand you correctly. That you do agree that so far Ms. Killam has not shown relevance to proving the Constitution and Code apply to Ian.
I don't
but
think
that she'll develop that
I really
later.
don't think that's required of her. You will be able to make arguments of law after the evidence is in. Right now, I'm hearing the evidence that they desire to present here today, and then I will hear arguments of law. But at this point,
I'm not arguing law. I'm talking about if the testimony of the officer is relevant to establishing that the Constitution and laws actually apply. Now, you've already said you're going to overrule the objection on the grounds that she'll lay that out later. So I just want to know. So it seems like you're in agreement that at this point she has not laid a proper foundation to show relevance of these questions.
all right. Would you like me to quote the Constitution of the State of New Hampshire to you, sir? I don't know if you've read it in preparation of the hearing today. But Article 5...
No, that's not what I'm asking. I'm not asking that at all, sir.
The legislature the power to enact laws. Article 6A is where the Constitution says that the legislature may make laws relating to the use of public highways in the state. That's the Constitution I'm going by here today, sir.
Well, I would object. That's not what I'm asking. And since you're raising that issue, let me ask you, because I didn't get a chance to do this before you threatened me. Are you under the impression or the opinion that the Constitution and laws of the state of New Hampshire apply to Ian?
I'm saying that the Constitution applies to the use of highways in the state of New Hampshire, and if Ian is shown here today to have misused or abused that privilege, then the state will have given me relevant evidence.
But the question I'm asking is, at this point in time, do you believe the Constitution and laws of the state of New Hampshire apply to Ian right now?
Well, since I haven't heard all the evidence, I can't give you a final determination on that.
Okay, well, that's what I'm looking for. So just for the record, you are not under the assumption or the perception that the Constitution...
Sir, I'm under the assumption, but I want to hear all the evidence before my assumption is either proved founded or unfounded. Because he is an inhabitant of the state of New Hampshire, I am under the assumption that the laws of the state of New Hampshire apply to him. You can prove to me otherwise, but right now, I am going forward on the basis that since he inhabits the state of New Hampshire laws apply to him. And we'll see how...
Well, I would object on that. I would object on that because that's an element that Ms. Killam is supposed to prove. She's supposed to prove that the Constitution and laws apply to Ian to make her case. That's the entire foundation of her case. This is why I was so adamant about that before we started, before you got upset and decided to threaten to cut my transmission. If you are already under the impression or the assumption that the Constitution and laws apply to Ian, you've already picked up Ms. Killam's burden of proof. How can Ian get a fair hearing here if you've already determined the foundation of Ms. Killam's case? That's why she sat there stone-faced the entire time I was asking about evidence that the Constitution and laws of the state apply to Ian. She doesn't have anything to offer. You're doing it for her right now. And I would object that we can't get a fair hearing from you, sir, by your own admission, because you've already determined a major element of Ms. Killam's case.
I presume anyone who inhabits the state of New Hampshire is subject to New Hampshire law, and if you can prove to me otherwise, that's where we'll go.
Can you define the state?
What evidence do you rely on? What evidence do you rely on from Ms. Killam to prove that the Constitution and laws actually apply to Ian?
I haven't relied on any evidence of hers yet. As an administrative hearings examiner, I am presumed to have specialized knowledge of the area within which I hold hearings. And that knowledge tells me that anyone who drives a motor vehicle in the state of New Hampshire is subject to the motor vehicle laws of the state of New Hampshire.
Well, that's your opinion. Now, what evidence do you base it on that the Constitution and laws actually apply to Ian?
It is an opinion that if you have evidence to rebut, I will certainly listen to it today. But I am a hearings examiner who is allowed special.
Sir, the one who makes the allegation bears the burden of proof. Okay, if you're going to assert that
he has misused or abused driving privileges in the state of New Hampshire, that's their burden of proof. And it's your
no, the burden of proof is
that
to show that it applies in the first place. The burden of proof is to show that the Constitution and laws actually apply to him, unless you want to go on record that it's being applied arbitrarily. If there is not concrete empirical proof that the Constitution and laws apply.
From the beginning, sir. Does the U.S. Constitution apply to Ian?
I don't see any evidence to that, sir. And if you believe so, then you better put up the empirical proof, and you better have a witness with personal first-hand knowledge, or you're purely speculating.
Okay,
we're not going to tolerate it.
This discussion isn't going to go anywhere, because if you believe that the U.S. Constitution doesn't apply to Ian, then of course you don't believe that the New Hampshire Constitution applies to Ian. But I have an obligation to hold this hearing, hear evidence as to whether he has misused and abused driving privileges in the state of New Hampshire. And that's what the state is.
I would object to your characterization.
I'm sorry?
The position we need to make clear is that there's no evidence to prove that the Constitutions apply to Ian. If you believe otherwise, then you need to put up the evidence.
I am here to uphold the Constitution of the state of New Hampshire, sir. So if I assume that it doesn't apply to Ian, or I make every person who comes in here prove that, I'm not upholding my responsibility that I took on when I took this job to uphold the Constitution of the state of New Hampshire. And that
you didn't take an oath to arbitrarily apply it to Ian Freeman, did you?
Arbitrary?
Did you take an oath to arbitrarily apply the Constitution to Ian Freeman?
I took an oath to apply the Constitution of the state of New Hampshire to everyone who appears in front of me.
I don't believe that that's what the oath you took. If you took an oath to uphold the Constitution, it does not mean that you were to arbitrarily apply it to everybody within your sights. We are here at an administrative hearing where there's a burden of proof, and you and Ms. Killam are making allegations and opinions against Mr. Freeman as if they are true. We're asking for the evidence that is based on. And prior, you accused me of disrupting the proceedings, and you threatened to cut my transmission only because I was asking for evidence that Ms. Killam is supposed to provide you in the first place. Now, is the opinion that the Constitution and laws apply to Ian arbitrary or not?
No, it's not at all arbitrary. It applies to everyone that appears.
Then it must be based on witnesses and evidence, and that is Ms. Killam's burden. She believes the Constitution and Code apply to Mr. Freeman. She has the burden of proving with empirical proof
and that is your opinion,
that it does.
And I am overruling.
No, it is not.
And I am going to continue with testimony over your objection.
Well, my objection is that it's not my opinion. You said it wasn't arbitrary. So by your admission, it's based on evidence and witnesses. We want to know what those witnesses are and what the evidence is. Unless you want to change your mind and tell the truth that it is an arbitrary decision that you're making and that Ms. Killam has made that.
A court of constitutional authority, sir. I am only here
I understand that, but
statutes and administrative rules of the state of New Hampshire. I don't have the right to make constitutional determinations. I absolutely don't.
I'm not asking you to.
Judges can do that. That can happen on appeal. I can't do it.
I'm not asking you to. Again, you're mischaracterizing what we have, which is an issue of fact. You keep mischaracterizing it as an issue of law. I'm not asking about the constitutionality of anything. What I'm discussing is what evidence do you have or Ms. Killam have? I don't know how I can interpret it any other way when you ask me if the Constitution applies to him, that you're asking me to make a constitutional determination. I'm asking for evidence that it applies to Mr. Freeman. It's an issue of fact, not an issue of law.
And
you keep conflating the two.
I'm trying to get facts on the table here so that I can make a determination.
But you've already made the determination. You've already stated on the record you believe the Constitution and laws apply to Ian, and you've heard no testimony, and you've got nothing from Ms. Killam to back that up. You insist it's not arbitrary, but when I ask you for the facts, then you go back and say you're not a constitutional authority. You just don't answer the question. What really needs to happen is you need to back up.
If Ian Freeman has used the roads of the state of New Hampshire, he is within my jurisdiction to hold this hearing. That's my ruling, and that's what I'm going with.
And I object because you've got no evidence to support that. You've got no evidence to prove the Constitution Code applied to Ian just because his physical location may have been in Keene.
And once again,
or
sir,
somewhere
I am
else in
going
New
to
Hampshire.
caution you that if you don't allow me to conduct this hearing and gather evidence, I am going to disconnect you, okay? I have ruled on your
Well,
objection.
I understand.
I have ruled on your objection. You keep repeating yourself, and I'm not going to have this. I'm not going to go back and forth with you on this. I have told you why I'm doing what I'm doing, and I'm going to continue to do it. And if you have an appropriate objection, if you have an appropriate objection to it, sir, at some point, then I will listen to it. But I'm not going to listen to you rehash the same thing every time.
Well, if you gave me a straight answer, sir, I wouldn't have to keep asking the
I think I have given you a
question.
straight answer, and I'm not giving you any further answers. Do you understand that?
Yeah, I have an objection that we would object that you have already demonstrated extreme bias against Mr. Freeman, that a fair hearing with you is not possible because you've already picked up Ms. Kilm's burden of proving that the constitutional laws actually apply to Mr. Freeman.
I'm overruling your objection. I'm going forward with the hearing. I will hear the evidence. I will make a determination.
Do we have a
based on
supervisor
it.
that you can bring this, we could take a short recess and we can put the motion before a supervisor?
I'm my supervisor, sir. I am the chief hearings examiner.
You're the chief?
Yes.
So a motion to change the hearing officer there's no one above you, there's no other judge or administrative law officer that we can bring this to make a decision? Because I want you to, what I would like to do is I would like you to tell them, I am assuming that the constitutional laws apply to Ian Freeman on behalf of Ms. Killam, and they're objecting to that. You're taking her burden of proof away from her and making it, much, much easier for her to establish her position. So I don't think it's right that we should have the decision made just by you.
Your request to have me recuse myself is denied, sir.
On what grounds?
I have not made up my mind on the case, but you are focusing on a particular aspect of the case that as I said, I do not have the authority to rule on constitutional issues. I have told you that if he used the roads of the state of New Hampshire, it gives me jurisdiction to hear the case, and I will hear the facts of his operation and why the city of Keene believes that operation is illegal or improper. That's my...
No, sir, you say, and I agree with you that you can take the facts. All I'm doing is asking you to provide me those facts. I'm not asking you for a constitutional determination. I'm asking you for the evidence that Ms. Killam is supposed to provide that the Constitution actually applies to Ian. It's an issue of fact.
You're making an assumption that I don't agree with.
What's that?
That she has to make a showing that the Constitution applies to Ian. I've told you the basis I'm conducting this hearing. He has used the roads of the state of New Hampshire. The city of Keene believes he may be doing that in an improper and illegal manner, and I need to hear the evidence to make a determination on that issue. Whether you believe the Constitution of New Hampshire applies to him or not is not anything I'm actually that worried about at this point. You can make legal arguments, and I am going to hear the facts of the case. Because he has used the roads of the state of New Hampshire, that gives me jurisdiction over that operation.
You're not concerned with the entire basis of her jurisdiction and her complaint that the Constitution laws apply. And I've asked you already what evidence you rely on to prove that the Constitution and laws apply to Ian just because he's physically in New Hampshire, and you don't have an answer for that. You just say, I'm not a constitutional scholar or something like that. You don't have any evidence to prove that.
I'm not a constitutional court.
Okay, I apologize. I got that wrong. But you keep doing that instead of just asking what evidence. If you believe the Constitution laws apply to Ian just because he's physically in New Hampshire, I want the evidence you rely on to prove that.
I am going forward, and I'm not going to repeat this anymore. I am going forward on whether the city of Keene meets its burden that he has misused and abused driving privileges in the state of New Hampshire, and that was as a result of operating on roads in the state of New Hampshire. The rest of it, to me, doesn't matter. Okay?
Okay, so it's an objection because I believe due process requires a notice and opportunity to be heard. You're telling me point blank that whether there's evidence that the Constitution laws apply in the first place is not something that you're going to entertain. You're just going to accept that as the gospel truth written in stone, and you're not going to allow us to challenge that.
I didn't say I wasn't going to allow you to challenge that. I simply said that I'm going forward in hearing evidence based on the fact that I need to understand whether he has used roads in the state of New Hampshire and whether that use has risen to the level of a misuse and abuse of his driving privileges. That's what this hearing is convened for. You will have every opportunity you want to make your arguments, but I need to hear this evidence to even get to that. Because it's the state's burden to go forward.
The point of clarification here, sir, with all due respect, if you're saying that the Constitution laws apply because they say so, because that's what I'm hearing from you, that the law says if you use the roads, the law applies. That's circular. That's not that's not evidence.
No.
So are you really having? Let me finish. Are you saying that the foundation of your position?
I have made my point clear. I am going forward on this hearing because there is a statute that they believe has been violated. I have the right to hold the hearing. I don't have to make a determination as to whether the Constitution and laws of the state apply to this gentleman, and you are certainly capable, it sounds like, of making that argument yourself once I have heard the state's case. And I am going to hear the state's case.
You're making an assumption that picks up her burden of proof that he was physically in New Hampshire, the laws apply. So I'm just trying to get
I'm waiting to hear that
for later
evidence,
if
sir.
this has to be
I'm
appealed.
waiting to hear that evidence, and you're not letting me.
Well, I made an objection that there was no relevance, and this is what got us started on this because you said, I wrote it down.
10 minutes ago. Do you
But that
realize
was on the grounds that she was going to build a foundation later. You said that she was going to build her foundation later, and I wanted a clarification from you that at this point in time, she has not shown any relevance to the question.
And I've overruled that objection, and I'm going to continue to take testimony. Please continue.
Okay, but you still haven't been clear that you're in agreement that she hasn't laid a foundation of relevance at this point. And I think it's highly disingenuous
I have made my ruling,
to
and
make
if you
a
are going to
statement.
continue to argue it, I am going to disconnect you. Do you understand that?
You don't need to disconnect. Don't do that.
You have created your record 5 times over. Okay. I want to hear evidence. Please continue.
That's what we want to hear, sir. But you've been disruptive yourself and not giving straight answers and threatening me. We were just here from the very beginning. All we've done is ask for evidence. That's all we've done. When she filed this nonsense in court, we just wanted the evidence. And so it's disingenuous for you to say, I just want to get to the evidence, when for the entire time we've been doing this.
Please continue. You can move
Sergeant,
that back over.
Sergeant Short, you had indicated that you initiated a motor vehicle stop of that vehicle.
I did.